And Your Honor, had the case gone to trial, multiple provided testimony that on March 5th of the year 2009, at approximately 1:43 p.m., Officer Lieutenant Bailey of the Tyngsboro Police Department was dispatched to Webster Road at Potash Hill Road for a reported motor vehicle crash. The speed limit on Webster Road is 35 miles per hour, and it is a public way in town of Tyngsboro. When Officer Bailey arrived, he observed two vehicles, a black Toyota Corolla and a white Chevrolet Corolla. They were both severely damaged in the middle of the road. The driver of the Corolla, Manuel Goncalves, was the sole occupant. He was unconscious and bleeding from his head. The driver of the Blazer, the defendant John Sullivan, also the sole occupant, appeared to be dazed and injured. Officer Bailey assisted medical personnel in removing the defendant from the Blazer. Officer Bailey also observed the airbag had deployed and it was still smoking. The interior of the defendant's vehicle smelled of airbag smoke. Officer Bailey spoke to the defendant who could not remember what had happened. The defendant was unable to identify what his injuries were. Officer Bailey worked on placing a neck collar on the defendant until Trinity Medical personnel arrived and treated the defendant at the scene and ultimately transported him to the clinic in Burlington. Patriot Ambulance personnel transported Mr. Goncalves to Lowell General Hospital. He was pronounced dead due to blunt force trauma, injuries to his head, torso, upper and lower extremities, all injuries sustained from the crash. An inventory of the defendant's vehicle was performed by Sergeant Christopher Chronopoulos of the Tyngsboro Police Department at the scene. Sergeant Chronopoulos recovered various prescription pills located in a black and tan bag in front of the passenger seat area of the defendant's vehicle. Subsequent to the crash, Officer Healy responded to late clinic to interview the defendant. Officer Healy advised about his Miranda rights. The defendant acknowledged and understood those rights and said that he was willing to speak with Officer Healy. Officer Healy was advised by a nurse that the defendant hadn't been given any medication or other medical treatment that would alter his level of consciousness. The defendant appeared in pain but lucid. The defendant at this time told Officer Healy he did not remember how the crash occurred and that he couldn't remember who he drove prior to the crash. The last moment he remembered was being on Sedgwick Street while visiting with his wife, and he was not sure how he arrived on Western Road. The defendant also told Officer Healy that he was diabetic and he takes insulin 4 times a day. The defendant said that he hadn't had his lunch that day but didn't know what it was. The defendant was able to recall Officer Healy's name, although it had been offered only once. During the course of this investigation, Officer Healy also spoke with a witness by the name of William Coleman. This witness stated he was driving northbound directly behind the Blazer, the defendant's vehicle, just prior to the crash. The witness stated that the Blazer was all over the road. He observed the Blazer cross a solid yellow line from the northbound travel lane into southbound travel lane and drive for approximately 50 feet in the southbound lane. The witness then saw the Corolla approaching. The Corolla was driving south in the southbound lane of travel. The Corolla swerved to the right of the breakdown lane, then to the left in an attempt to avoid the Blazer. The Blazer struck the Corolla head-on. Massachusetts Trooper Joseph Baglietto of the State Police Reconstruction Unit responded to the scene on March 5th to assist with the investigation. He searched the road for physical evidence and found a rim gouge mark from the left front tire of the defendant's vehicle on the center line. In Trooper Baglietto's opinion, this gouge mark indicates that the defendant's vehicle encroached into the victim's lane of travel, causing the vehicles to crash head-on in the victim's lane. Also during the course of the investigation, Detective Sean Wagner of the Tyngsboro Police Department obtained a search warrant for the medical records of the defendant from Lake Clinic for the time period that he was there, which was from March 5th of 2009 to March 11th. The medical records indicate the defendant suffers from diabetes. The defendant's ethanol level was at 208, which reversed to a blood alcohol content of 0.18. Those are facts.
Thank you, Mr. Sullivan, will you understand the facts that were just stated to the court by these?
He is no longer accompanied by his dad and my cousin, who also expressed great support throughout my representation throughout Mr. Sullivan's tendency to this case. He was born and raised in Lowell. He has lived in the same home in Tyngsboro for nearly 30 years, where he's raised 3 children. They're all in their 20s. His daughter, his youngest child, is still in college. He is himself a college grad, as we began to report from he suffers, as far as from very, very bad health. I provided the court and provided the government with summary excerpts from 4 different doctors. medical condition, and I won't go into great detail, but he has pancreatic complications, his stomach complications, liver complications. He's an insulin-dependent diabetic. He's under the care of virtually a team of medical physicians. He is, however, more importantly, he's quite aware of what happened in this case. He's quite contrite. He's expressed that to me. He is a man who's involved with his church, St. Catherine's, and that's in New Hampshire. There's an issue at some point where they are in the process of making sure they have permission to go there. He tells me about he's tried to make the nutrition he has made, the religious state of prayers he has made, family have deceived, or he's truly sorry. He's been, as I say, he's been in the community, he's been active in a variety of community affairs, he's been involved in charitable affairs, he's involved in various fundraisers, to help children with scholarships, he's involved in helping with disabled veterans and from local sporting clubs. He volunteers his time for various community grade activities, where he acts as a truck, he's involved in the so he is a middle-aged individual who's about to face the shock of his life. Clearly, he understands that the consequences he's facing are not the same as the consequences that Mr. Goncalves has faced. But he's about to face incarceration. His life is ended as he wants to live as far as his day-to-day affairs. His employment is jeopardized. His family has been torn apart by the circumstance. He's about to face a 15-year loss of license after the 4 years of age. He stands before you, Your Honor, accepting responsibility, expressing his contrition for his acts, and ask Your Honor to impose a sentence that we've previously discussed. My recommendation is less than Your Honor indicated that you were inclined to give, but I think the combined sentence that Your Honor mentioned of a 2-year sentence split the period hanging over his head, 5 years probation, with providing the Commonwealth with a period of oversight, as well as a period of incarceration, which I suggest is appropriate under the circumstances. I know these are tough cases for the court. I can only say that I have done nothing else. I can't go to research and found numerous cases in which the disposition in a case like this is, in fact, that sentence that Your Honor is considering. And I would ask Your Honor to impose that sentence.
Thank you, Mr. Clerk. The defendant, John Sullivan, has pleaded guilty to a single indictment charging him with motor vehicle homicide under the influence of alcohol in violation of General Laws, Chapter 90, Section 24G. The charges arose out of an incident that occurred on March 5, 2009, in the early afternoon. The defendant was driving alone in a Chevrolet Trailblazer SUV on Westford Road in Tyngsboro when he crossed over the solid yellow center line and collided head-on with a Toyota Corolla being driven by the 70-year-old victim, Manuel Goncalves. Both vehicles were extensively damaged and had to be towed from the scene. Both men were transported by ambulance to the hospital. Mr. Goncalves died later that day as a result of blunt force traumatic injuries to his head, torso, and upper and lower extremities. Mr. Goncalves had been in excellent health prior to the accident. The defendant, who has insulin-dependent diabetes, had a very low blood glucose reading at the time of the accident, which likely affected his alertness and mental status. Additionally, his blood alcohol level was 0.18, significantly above the legal limit. An eyewitness who was driving directly behind the defendant just prior to the accident described the defendant's vehicle as being all over the road and saw the victim's Corolla swerve in an unsuccessful attempt to avoid the collision. The statute provides for punishment by imprisonment in a state prison for not less than 2.5 years or more than 15 years, and a fine of not more than $5,000, or by imprisonment in a jail or house of correction for not less than 1 year or more than 2.5 years, and a fine of not more than $5,000. The statute also requires that the defendant serve a minimum mandatory term of 1 year and that he loses his right to operate a motor vehicle for 15 years. In crafting an appropriate sentence in this case, the court has considered the following: the nature and seriousness of the offense as described, defendant's age is 64 years old. The defendant's social history: he has been married and has lived in the same home for over 30 years, has 3 adult children, has been steadily employed throughout his life, and has participated in a number of community activities. The defendant's medical history is reflected in several letters from his treating physicians that were provided to the court. For many years, Mr. Sullivan has suffered from difficult to manage diabetes, requiring him to take multiple daily insulin injections. He also suffers from pancreatic failure and takes a number of other daily medications in addition to insulin. He has liver disease and has been evaluated for a liver transplant, and he has been hospitalized 1 to 3 times a year for the past 5 years. The defendant's history of using alcohol and the defendant's lack of a significant prior criminal record. The court has considered the purposes of sentencing, that is, providing a just punishment for the offense, protecting the community, deterring future criminal conduct, and providing appropriate opportunities for rehabilitation. The court has also considered the impact this crime has had on the family of the victim, Mr. Manuel Goncalves. With the consent of counsel, I met privately with Mr. Goncalves' wife and daughter to discuss their views as to an appropriate disposition and to hear about the impact of this case on their lives. While acknowledging their understanding of the court's role and the goals of sentencing, as well as their faith in the system, both emphasized the unfairness of any sentence which will permit the defendant to spend his life with his family while they have lost their husband and father, and their own family circle has been irreparably and permanently diminished. They remain understandably devastated by the effects of this tragic loss. The court is mindful that nothing can restore the life of their beloved husband and father, and that no sentence can in any way compensate for the loss of that precious life. Finally, the court has considered the recommendations of counsel. The Commonwealth has recommended a sentence of 3 to 5 years in state prison, and the defendant has recommended a split sentence to the House of Correction from an act of probation, as well as the sentencing guidelines calculated by the probation department, which are level 6A, or period of 40 to 60 months. The defendant has no or minor prior criminal record. After a thorough consideration of all factors set forth above, it is the opinion of this court that the goals of punishment, deterrence, protecting the community, and providing an opportunity for rehabilitation will best be met by putting Mr. Sullivan on probation for a significant period of time following a term of incarceration. To this end, the court is of the view that a split sentence to the House of Correction from and after supervised probation and special conditions is the most appropriate disposition for this case. Therefore, the defendant shall be sentenced to 2.5 years in the House of Correction with 2 years to serve. The balance of the sentence shall be suspended for a period of 5 years with probation to be served from and after Mr. Sullivan's release from custody. Specific conditions of probation shall include the following: the defendant shall refrain from any use of alcohol and shall submit to evaluation and treatment for alcohol abuse at the discretion of the probation department. The defendant shall wear an electronic bracelet for the first year of his probation and shall be subject to random intoxicator testing for alcohol during that time period. Following the removal of the bracelet, the defendant shall continue to submit to random alcohol screening by the probation department, and the defendant shall not operate a motor vehicle during the term of his probation. As I noted previously, Mr. Sullivan will also be subject to a 15-year mandatory license loss as a result of his conviction for this offense. Additionally, the court shall impose a maximum fine of $5,000. You may impose a sentence, Mr. Sullivan.
Additional